be disagreed to, and I call the member for Bean.
Deputy Speaker, I also rise to speak on this bill and recognise the contributions by members previous to me in this debate. Deputy Speaker, another magnificently Orwellian-titled bill, the Corporations Amendment Improving Outcomes for Litigation Funding Participants Bill 2021. Another bill which will not do what it says on the tin. Another bill, in fact, which will do the opposite and, as previous speakers have said, will make it more difficult for not just my constituents of Bean, but constituents right across the country to access justice. So, Deputy Speaker, the stated intent of this bill is to protect the interests of plaintiffs in class actions by setting limits on litigation funding schemes being funded class actions, primarily by first providing that a court must approve or vary the distribution of claim proceeds as between class members, lawyers and funders as fair and reasonable, and secondly, to that end, imposing a rebuttable presumption that a proposed distribution will not be fair and reasonable if less than 70% of proceeds go to the plaintiffs. However, Deputy Speaker, it's clear that this bill is primarily aimed at making class actions more difficult for plaintiffs and to protect the interests of wealthy and powerful defendants. This isn't a new story, Deputy Speaker, but part of a continued pattern of hostility on the part of coalition members to the ability of individuals to access justice through class action lawsuits. In Asbestos Awareness Month, this bill is particularly galling. It should be noted as part of this process, and it's been a pretty rushed process, Deputy Speaker, that the Treasury certified a partisan report by government members of the Parliamentary Joint Committee on Corporations and Financial Services as an independent report as the equivalent of a regulatory impact statement for the many measures outlined in this bill. Just quite flabbergasting, Deputy Speaker, as someone who in a previous life had to put many regulatory impact statements together. The bill has been subject to an incredibly short inquiry through the Parliamentary Joint Committee on Corporations and Financial Services. And not only was that inquiry short, but it provided very limited opportunities for public engagement, including only providing a one-week period for people to make submissions. One week. If this is such an urgent bill to get through, there should have been appropriate consultation. Thankfully, Labor members of the committee opposed the bill and produced a dissenting report, a report that recommended that this bill should not be passed, Deputy Speaker. And Deputy Speaker, as I said earlier, the stated objective of this bill is to protect the interests of plaintiffs in class actions. But the real, though unstated, objective of the bill is to protect the interests of the powerful defendants by making it more difficult for people to bring class actions in the first place. It's a testament to the current government's incompetence that the bill fails to achieve either the real or the stated objective. As one of the submitters to the committee, in that very short time span, Finney McDonald put it, that the government is seeking to present this reform as a consumer protection measure is Orwellian gaslighting. Further highlighting the idiocy of this legislation is that it is opposed by leading class action defendant lawyers Herbert Smith Freehills. Finney McDonald wasn't alone in his assessment, Deputy Speaker. The committee heard overwhelming evidence that most of the measures in this bill would leave class action plaintiffs and defendants significantly worse off. For example, the evidence received by the committee strongly indicated that the overall impact of the rebuttal 70-30 presumption would in fact be to drive up litigation costs, discourage plaintiffs and defendants from settling disputes, and so, in fact, delay the resolution process, and more generally, make the law worse for everyone. Moreover, as such a presumption would also raise the risk for funders, no funding would be available for some meritorious claims, and funding costs for all claims would likely be higher than they otherwise would be. And Deputy Speaker, most submitters argue that rather than resolving uncertainty in the existing law in relation to the availability of common fund orders as recommended by all the members of the committee back in December 2020, instead the bill promotes uncertainty and confusion around common fund orders to the detriment of plaintiffs and defendants in class actions. And Deputy Speaker, by requiring class members to agree in writing to be members of a litigation funding scheme, submitters have argued that the bill would lead to an increase in the number of closed class actions, and this would in turn result in multiple class actions for a given event. In other words, it would actually lead to much greater inefficiency and possibly much greater litigation costs. Deputy Speaker, it's also important to mention that while the explanatory memorandum acknowledges that the bill gives rise to a range of regulatory impacts on business, the committee in making the dissenting report into this bill makes the point that those impacts have not been properly considered or even understood by the Treasury or the government. And that is because instead of preparing a comprehensive regulatory impact statement in relation to the bill, Deputy Speaker, something, as I mentioned earlier, a task I've been involved in previously myself, the Treasury certified a report by Liberal members of the committee as an independent review which involved a process and analysis equivalent to arrears. Quite extraordinary, really. In other words, the Department of Treasury certified a report written by Government MPs as independent and then used that report as a primary justification for going forward with this bill. But, Deputy Speaker, there are also broader constitutional concerns around the validity of this bill. According to the Law Council, former Solicitor General Justin Gleeson SC and other legal experts, it's not clear that the bill is constitutional. Multiple and serious concerns were raised in submissions, including, but not limited to, whether the corporation's power in the Constitution and or the referral powers to the Commonwealth can support the provisions in the bill, whether the provisions would amount to an inconsistency with state class actions provisions so as to override them pursuant to Section 109 of the Constitution, including impacts on the group costs order provisions unique to the Supreme Court of Victoria, and potential issues arising in respect of overriding the power of state courts or directing state legislatures. The explanatory memorandum fails to mention or address these constitutional questions in any way. Indeed, Deputy Speaker, in response to these concerns raised in submissions, the Attorney-General's Department itself was unable to provide the committee with any meaningful assurance that the bill was constitutional or offer any rebuttal whatsoever to any of the concerns set out in Mr Gleeson SC's legal opinion. There was literally no explanation offered as to how or why the bill is constitutional. Indeed, according to the dissenting report, it was clear from the long silences, non-answers and visible discomfort at the questions that the officials from the AG's department harboured doubts themselves as to the bill's constitutionality. It's extraordinary for it to have been brought forward without these questions having been answered. But, Deputy Speaker, in relation to these concerns, many of these concerns have been raised again most recently in a decision by Justice Beach of the Federal Court of Australia just on the 17th of November 2021, which again in Stanwell Corporation Limited and LCM Funding Proprietary Limited again raised some of these issues around the constitutionality and drafting of the bill, and actually went to some of the rationale behind this bill. Some of the comments, Deputy Speaker, in that judgment include, in relation to the bill, that the bill may need to be modified to bring its scope within the referral contemplated by paragraph 51(32) of the Constitution. It may need to be modified to address direct or indirect conflicts with the provisions of Part 4A of the FCA Act. This is only a week ago, Deputy Speaker. In the same decision, Justice Beach found that the proceeding dispels the myth of the so-called advantages of book building in a case of this type. The book building here has resulted in an unnecessary, costly and inefficient delay of 7 months in order that over 50,000 retail customers be separately signed up to individual funding agreements. There's little justification for such a barrier to entry, so to speak, or justice. And to allow the proceeding to remain closed will incentivise others to launch parasitic actions to cover the balance of the universe of electricity consumers. So the potential for a multiplicity of proceedings, and indeed, if not productive of such multiplicity now, that position may be all but inevitable if I later deliver a judgment in favour of the present closed class unless I open the class after judgment. And yet, that is what this bill will do. That is exactly what this bill will invite, Deputy Speaker. But, Deputy Speaker, it's not just about those particular important issues that go to the constitutionality of the bill, but it does go to the real-world impacts. This isn't merely some sort of academic process. There are many landmark class actions that wouldn't have gone ahead if we had actually had the measures in this bill been in place. And my colleague, the member for Morden, has provided some of those examples. A great example: the Mervyn Street and State of Western Australia, otherwise known as the West Australian Stolen Wages Class Action. A class action involving thousands of Indigenous Australians in Western Australia whose wages were unjustly withheld or not paid as a result of wage control legislation in effect until 1972. Eileen Cummings and the Commonwealth of Australia, a class action involving stolen generation survivors, Deputy Speaker. Gregory John Lenthal and Westpac Banking Corporation, another, which was a class action alleging that Westpac overcharged its life insurance customers. I think there's a bit of a theme emerging here, Deputy Speaker, about who exactly is going to be excluded if these measures actually go through. Hudson and the Commonwealth, an environmental contamination class action against the Commonwealth of Australia relating to chemical contamination at Army Aviation Centre at Oakey in Queensland, which resolved losses in property and business values. A couple of my colleagues in this House have worked hard to bring those key concerns about the consequences of PFAS, the impacts on small farms and tenancies outside defence bases. The idea that those sorts of participants should be excluded, Deputy Speaker, is quite extraordinary. Riley Gall and Domino's Pizza Enterprises, a class action board of delivery drivers and in-store workers who alleged systematic underpayment relative to award entitlements. Well, Deputy Speaker, we shouldn't be surprised at that last example about why this government would like to exclude such actions from coming forward, even when they do try and give Orwellian titles to their legislation at times which allege that they are acting as if they're on our side, acting as if they are on the side of working people and their families across this country. And, Deputy Speaker, the minority dissenting report into this bill finally came down to make the case that, in the end, the proponents of this bill just, they haven't made their case. And today, again, they haven't made their case. This bill should be voted down.